And welcome once again to the Disability Law Show. So good to have you along for the next half hour. John Scholes here. Joining us shortly across the table, Tamar Agopian, Samfiru, Tumarkin, LLP. I want to reach out to Tamar anytime. We'll discuss the matters on every show. She's the pro. She's got all the information. I just steer the ship, right? She fills it. She really needs to be here, is what I'm saying. The phone number, anytime you guys want to reach out when we're not doing this show, 1-855-821-5900, help@disabilityrights.ca, and a website, pocketdisabilitylawyer.ca. You can use that anytime. We'll give you details on how that works in just a bit. We have a main topic again this week, like we always do. What you need to know if your disability is due to a workplace injury. That's coming up in a bit, but tomorrow we always start off with a case or something you've been working on, pal. What do you got this week?
Well, we have our free consultations, which we offer to everyone who would like to get some advice on their disability claim. And I spoke to someone this week, super interesting situation, and I really want to feature her situation because it touches on a subject that we don't always talk about, and that's the recurrence clause in these disability policies. So she reached out to us. She is in her 50s. She was working as essentially a support worker, like a PSW type aid worker in a nursing home setting. Very physical job. She had had some physical issues along the way, and her workplace had actually accommodated her for a number of years before it got to a point where her doctor said to her, "You need to stop working. This isn't working for you, and we're going to start the process of a disability claim." She in particular had significant knee issues. One knee at first, and then how these things go, then the second knee started to go. She actually had to see 2 different physiotherapists before she was finally diagnosed with a nerve issue in one of her knees and then her second knee. The reason why I bring up that whole process was because she was approved for short-term disability benefits, John, but was denied for long-term disability benefits on more than one occasion because she decided to appeal. So she went through 2 appeals and in the end was still denied with her disability claim. And so she had been going without any income support for nearly a year before she contacted us and said, "Look, what are my options? What can I do in a situation like this? Now I finally have the diagnosis that I need, and yet it doesn't seem to be persuading the insurance company that I have a disability claim that should be paid or payable. And I feel as though I'm being forced to return back to work." And this is the harsh reality of not only my frustrations around the appeal process, but also the desperation that people feel when they go through this process and in the end feel like their only option is actually putting themselves back into a work situation that had put them off in the first place. So among the many different things that we spoke to her about, and there are some options, I wanted to feature, like I said at the top, this idea about a recurrence claim. How does this work, John? These policies have a section in them that say, if you're off and we pay you, we don't pay you regardless, and you go back to work and your health issues prevent you from working again, then the policy is meant to respond to a situation like that. Long-term disability benefits in particular have a waiting period. You don't actually qualify for LTD unless you've gone through a waiting period that should typically line up with either short-term disability benefits or EI sickness benefits. When you have a recurrence claim, though, you don't have to wait that waiting period. You're meant to submit medical information again to the insurance company. Insurance company is supposed to look at it and say, yep, your doctors are putting you off work again. It's the same health issues or related health issues, and we're going to kick back up those LTD benefits. And the reason why I spoke to her so deeply around that recurrence provision was because of the desperation that she was in. And what she was saying to me was, look, I'm just going to ask my doctor to sign me off and return me back to work because I have to get some. I give up. I give up, John. And it really, really frustrated me because there are other options, absolutely. And when people are denied initially out of the gates, especially when they're being resisted from moving from short-term to long-term, and their doctor is still supporting that they're disabled, the test is the same. There's no reason why she shouldn't have been put on an approval mode or approved her LTD claim. And the only thing that I can surmise is that I think that the insurance company was relying on the fact that her employer had accommodated her before she went down this path. So I think that they improperly looked at her profile, looked at the job duties that she was doing before she went off on disability, and suggested to her, look, we think you can go back to that accommodated role. But her employer has said to her that accommodation is no longer available to her. She has to go back to full duties, full responsibilities. And so this is what the recurrence provision is meant to provide for. So if you do end up, and there's a whole host of problems, right, John?
Sure.
I mean, the employer has duties, the insurance company has duties. But strictly on this issue of recurrence, I don't want people to think that that closes the door for long-term disability benefits if A, you weren't approved out of the gates, or B, you do put yourself back into a situation where you can't work, and then you end up being right back to where you were, where you can't work again. That is what disability benefits are meant to cover for. If you are totally disabled, at least in this phase for this particular individual, that initial phase from working at your duties, doing those essential duties of your occupation, you are entitled to long-term disability benefits. And the fact that she's being resisted, I think, has more to do with her work situation, perhaps the relationship between the employer and the insurance company. I can only guess a few different options. But at the end of the day, you will need your doctor's support to make these kinds of claims. And the medical information becomes that much more important if you are then pursuing a recurrence claim. You have to make sure that you're getting that endorsement from your doctors and then submitting that information to the insurance company to reconsider whether or not you're entitled to that benefit.
The thing I find interesting about this, you mentioned off the top, we've heard this story before, is they're okay on short-term disability, which is usually 100%, but then when you apply and try to go on long-term, you get denied, which is 65%. Would that be possibly because the short-term is paid by the employer? And then once the insurance company has to start coughing up some shekels, they're like, no, it's not going to happen.
That's it exactly, John, is that is definitely part of the element of this profile, is that very much so, the insurance company may simply be administering or adjudicating, reviewing the medical information for the employer for the short-term disability benefits, but those benefits are paid. The actual money comes from your employer for short-term. In some circumstances, not in all circumstances. And then when it shifts over to long-term disability benefits, it is the long-term disability insurer's money. So they are now the gatekeeper of their own funds and therefore can resist the transition from short-term to long-term, even though there's no proper basis for doing so. But because they do not want to have to pay that long-term disability benefit, they want to make it the employer's problem, because they probably looked at her profile and thought, if once we get her on, we're going to have a hard time getting her back in either a job or an accommodated position or in some other role. And so the policy is there, yes, to be used by insurance companies at times to deny claims, but also it's meant to protect individuals who are insured under them. And the courts have recognized this. It is supposed to be a peace of mind policy. It's supposed to be there for situations like this. And when it is not, and insurance companies are not making the right decisions, this is really where we step in. And one of the options I gave her was, look, I understand the financial constraints, but you have a right to a legal claim here, and that is where we can help people. We can also facilitate getting further medical information for you. We take all of that away. But the reality is that it does take some time, not forever. We can resolve these things in months, but when you've gone down this appeal process for months and months already, this is why that process is so effective for insurance companies, because it does force people back. And they are therefore using their process and their policy to their greatest advantage and collecting those premiums and resisting having to pay out valid disability claims.
As mentioned off the top, there's a free and anonymous website for you to check out any time. You can learn lots from it as well, even before the phone call to Tamar and her group. That's pocketdisabilitylawyer.ca. It's pretty new, Tamar. Tell me about it. Why do you like it?
You know, these tools are fantastic because it shifts the balance a little bit back towards claimants. It gives them free information. Information oftentimes the insurance company won't give you or doesn't want you to have. And so we've created these tools, John. The Pocket Disability Lawyer, like the Pocket Employment Lawyer, is an anonymous tool. It's one where you can plug in some simple information and get very straightforward, efficient advice on whether or not you've got a basis for a claim or what your rights might be. No legal speak. Very, very simple. And the best part of it is that there's no obligation. You can close out that browser. We're none the wiser. No one's going to contact you. And in fact, there's a section there that says, would you like someone from our team to contact you? And if you want no, that's absolutely okay as well. But really, really good tool as a starting point to figure out, look, do I have rights? Where do I go? What do I do? this is one of the great websites to help people do that in a very clear and efficient way.
Again, pocketdisabilitylawyer.ca is where you'll find that. Free and anonymous, as Tamar just said. I think we got time for an email before we get into our first break for the show. Stanley is the first one out of the gate. Tamar says, my best friend just received a denial letter in the mail from his LTD insurer. They stated that they don't consider him, quote, totally disabled, end quote, and believe he can do sedentary work. He's been off work for almost 8 months now because of severe back pain. Is there anything you can do to help?
Yes, Stanley, we can help, absolutely. If he is being denied and his doctors are supporting his disability claim, this is where the insurance company is not on good footing. They're not on good footing, John, because the test for disability when you first apply is normally, are you totally disabled from doing your own occupation? Now, we don't know exactly what type of job Stanley's friend is doing, but when I read that the insurance company is saying he can do a sedentary occupation or a sedentary work, that tells me it's basically a job where you're mostly sitting and you don't have that physicality of your work. Well, he's got a physical disability, and even with the severe back pain and a job where you're mostly sitting, that doesn't necessarily fly. I mean, even sitting in and of itself can be very difficult for people who have severe back pain. Those two things are not aligning, which is why I think it's so important to assert those legal rights and not waste that time doing the things that the insurance company wants you to do, which is, well, submit another medical information, maybe we'll look at it again, maybe we'll have one of our doctors review it. That's the path I don't want to see have happen, because the insurance company has already said no. And they've said no at the 8th month mark. So it's not going to change their mind at the 9th month mark or 10th month mark. This is a situation where by the time those decisions are made by the insurance company, by the time potentially you've gone through the appeal process, we probably could have had the case open and shut and resolved for Stanley's friend. And again, the key here is, what is the doctor supporting? Because, John, we know that these insurers can do rehabilitation, they can do assessments. I don't know what they're relying upon to actually conclude that Stanley's friend can work, but at the end of the day, if his own doctors or her own doctors are supporting the claim, then the courts have recognized that establishes total disability and you're entitled to disability benefits.
Stanley, appreciate the email. I know you follow up with a phone call after the show. We've got to get into that first break, as I mentioned, and when we come back, our main topic, what you need to know if your disability is due to a workplace injury. That is coming up on the Disability Law Show, so stand by for it.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Disability Law Show. As always, John Scholes, and joining me, Tamar Agopian. You want to reach out to Tamar anytime. A phone call is always welcome. No obligation. Just have a chat. 1-855-821-5900. Help at disabilityrights.ca. Disabilityrights.ca. Okay, main topic, Tamar. What you need to know if your disability is due to a workplace injury. Number one, even if you have filed a workers' compensation claim, you should also file a long-term disability claim with your insurance provider. Psychological injuries due to workplace harassment are also compensable as workplace injuries. What do you say about all that?
It's a lot there. So let's take it back a step and let me just explain the two elements here. What we're talking about is workers' compensation benefits, which exist in all the provinces we practice in. Whether it's called WorkSafe or workers' compensation, those regimes exist in most provinces and for most employees. But most employees also have access to individual disability benefits from a plan that they have with their employer. And you are absolutely entitled to both, even if your disability arose from an issue or a workplace injury. And that's really what we want to focus on for our topic today, because it can be confusing. And actually, I have found that some employers don't even really necessarily navigate their employees properly to say, you should start both processes. And they are different. And it is a lot of paperwork, I'll admit that, but you want to make sure that you are both applying for workers' compensation or WorkSafe, and that you are applying for short-term and long-term disability. And those different benefits exist whether or not you have a physical disability or a mental health disability. The workers' compensation regime was changed in a few provinces, Ontario in particular, some years back, to allow for these types of claims to be made where you've got a mental health disability that arises from your work setting. Let's say it's a toxic work environment or harassment at work and so on. I'm not going to promise you that you're going to be approved for any of these types of claims, but as a starting point, you must apply. You should apply, because if you don't apply, you don't get, right? And so that is really where I wanted to start with this topic, is that you want to make sure that you put in both those applications, and it will require some cooperation from your own employer, who also has to submit forms, incident report, this kind of thing, both for the WorkSafe workers' compensation realm and for short-term and long-term. But more to the point is that, how do they work together, John? And they do work together. In most disability policies, there will be a section in the policy that says, if your disability gives you a right to other compensation, other sources of income or benefits, then the disability insurer gets to take a credit for that. And workers' compensation is one of the big ones, because workers' compensation typically will pay you at a higher percentage than long-term disability. I think we even said it at the top of the show, right? Long-term disability is usually about 2/3 of what you're making, whereas workers' compensation is 70 to 75% of what you were making, so a little bit higher. Regardless, though, what if workers' compensation doesn't approve you for the income amount? They might give you rehabilitation, but maybe they don't approve you for income. So then what happens? Well, LTD then doesn't get a credit for that. You want to make sure that you're getting that income support from the long-term disability insurer. This is why it's so important to apply for both and just see where it sort of leads you. But we can sort of talk that through with our other couple of points we want to make on this topic today.
You bet. Number two is that workplace injuries or illnesses can lead to health issues covered by LTD benefits, right?
Absolutely. And so just because it starts out as a workplace injury doesn't mean that it's not going to be prolonged enough or long enough to get you from short-term to long-term disability. And so again, this is something that can be, I want to say, confusing at times, because a doctor's not necessarily going to be able to guide you as to where to go and what to do if you've been off work for 3 months, 4 months, 5 months, 6 months. And that's really the window of time where you have to make some choices medically with your own medical team about whether or not you're going to be capable of returning back to work. And this is why, just because you were hurt at work and you didn't, get healed or resolved or felt better in that window of time, doesn't mean that it disentitles you for pursuing long-term disability benefits. And so the fact that it started as a workplace injury is not in and of itself a reason for not applying for long-term disability benefits.
Point number three is this, Tamar: contact a disability lawyer. Indeed, you should always, if the insurance company denies your LTD claim because they believe it's a workplace injury, and they'll do that.
This is the most common reason that we see insurance companies deny claims, when they realize or see that the health issues arose in the work setting. A very simple example, broken arm using a certain piece of equipment at work. That's something, for example, that can entitle you to both workers' compensation and disability benefits. Mental health claims, though, as we said from the start, that's less clear, right? And so this is where we see a lot of resistance from disability insurers who want to suggest that because you had a toxic work environment or a mental health condition that was triggered by your workplace, this therefore must mean that you're avoiding working, and this is not a valid reason for being provided or approved for long-term disability benefits. That is not correct. That analysis is not correct, and it doesn't stand with the current state of the law or even these disability policies. We can talk a lot about that interaction between your work situation and your health situation, But at the end of the day, if your doctors are supporting that you cannot work, regardless of how your injuries or illness were caused, that is irrelevant for the analysis of getting approved for long-term. And this is where I get quite frustrated, John, because people then assume, well, this must therefore mean it's a work issue. I guess I'll get a sign-off and return back to work. Sometimes they don't even pursue workers' compensation, which, by the way, is not an area that we specialize in, but certainly we see a lot of this kind of interaction. And as I said, we see a lot of resistance from insurers when they see that the core issue for the disability is something that started in the work setting.
And with that, we hope you gleaned a lot of information from that. Again, you can always call Tamar and her team if you're a little confused. As we get into a break, another website called mydisabilityquestions.com. You can use that anytime. It's free and anonymous. And that's where our next question is coming, right here on the Disability Law Show. Stick around.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Disability Law Show again this week. John Scholes, Tamar Agopian, reaching out anytime. That's up to you when you want to make that happen. Feel free to pick up a phone, 1-855-821-5900, help at disabilityrights.ca, or as I mentioned going into the break moments ago, mydisabilityquestions.com. That's a beauty because it's free, it's anonymous. You can type in your questions. If it's been asked previously, the database is searchable, so it'll save you some time. But I want to get to this one. For this show, Tamar, goes like this from Sam, says, if someone is approved for short-term disability benefits, does it mean they will automatically be approved for LTD as well?
Easy answer.
Yeah.
No. It's not automatic, John, because as we said earlier in the show, is that there could be a different insurer, could be a different administrator, could even mean that you have to make a fresh application. And the starting point to ask those questions is to your employer if you're talking about a group disability plan. So you don't ever want to assume that you're just simply going to transition from short-term to long-term. I want to make a very, very clear point here as well, is that in theory, though, you should, right? In theory, it is the same test to qualify for short-term disability benefits under most policies and that first phase, the own occupation phase of the long-term disability policy. And there are a whole host of reasons why you might get resisted or denied in that transition, which we talked about. But if you don't make that application, you lose that right entirely. And so I cannot emphasize it enough that you want to be informed and you want to make sure that you don't miss the time frames in which to make that application. Because there's one insurer, John, that likes to use that as a reason to deny an LTD claim. They say, well, we never got the application. We were never notified. We didn't know this is something you were going to pursue. And people have been caught out in a situation like that when the policy has very short time frames in which to make that application. So do it, and don't assume you're going to transition. But if your doctors are supporting it, then you know you have a right to it, and that's what we're here to do, is to help.
Sam, appreciate that note on mydisabilityquestions.com. I want to bounce over to a quick email. We got some time here. Wyatt is up next. Says, my brother was denied LTD due to severe concussion. Despite his medical team's advice against working, he already gave his insurer all medical records from a local brain injury clinic and is currently paying for physio out of pocket. The insurance company has invited him to appeal. Is that the best option?
It is not the best option, John. It is not the best option, because what I can tell from this email from Wyatt is that the insurance company has all the information. They have all of the information. They have a diagnosis. They have a treatment plan. It sounds like Wyatt's brother is getting the right treatment for a brain concussion, which is very severe and can take a long time to, treat and be approved for. And so when the insurance company has all of this information, why are they then denying the claim, right? I want to understand why they're denying it and why they are suggesting for you to appeal. They just want to invite you to submit more information, but what more information could there possibly be that they don't already have? This tells me that there's something else going on. Perhaps the insurance company doesn't want to have Wyatt's brother on claim. He's been on this path now for several months, it sounds like. I mean, he's paying for treatment out of pocket, which in and of itself is a problem, but he is committed to that process. And what I don't like is the idea that he's going to continue to submit himself through the process of the appeal, which I can tell you can sometimes take longer than allowing lawyers like us to help you. Please, let us start that legal claim. John, we can leverage all of the risks around this, all of the sophistication around the health issues. We understand these kinds of injuries, and we can leverage that to get an excellent result for clients and people in situations like Wyatt's brother.
Wyatt, appreciate that. And we're going to go back over to mydisabilityquestions.com for a moment here. Get one more from Marcus this time. It says, my physician provided a note to my insurer stating that I can't attend another assessment and it worsens my PTSD and anxiety. Despite this, my insurance provider has threatened to cut me off if I don't go for another IME. What are my rights here?
Well, this is one where I say fairly quickly that if you've already submitted yourself through to one IME, unless it's a different doctor or specialty that they want you to submit yourself to, I think it's fair to resist that assessment. If they have all of the information that they need, I also think that it's fair to resist that assessment. And so in a situation like this, I would say the policy is important to review, find out what it says in there about rights around getting that IME. What is the insurance company allowed to do in terms of these kinds of assessments? And are they in a one and done type situation? And then above that is even this idea of this mutual cooperation. So they're threatening to cut him off if he doesn't go through to another IME. And the problem, of course, with that is that maybe they're not entitled to another IME. That's what I'm getting at. Mm-hmm. And that threat is something that people often submit themselves to, and it's not necessarily the right course of action. And so when I think about this profile, I first of all want more information. I want to see what the policy says, and I think I would like to see some support from their own doctors, Marcus's own doctors, around the fact that the PTSD and the anxiety in and of itself prevents him from talking to yet another doctor about all of his health issues. That can be really, really challenging. And so I think when I look at this type of situation and the fact that there's that threat of the cutoff, yes, you have an obligation to cooperate with your insurer, but that cooperation has limits. And when it is contrary to your health and your conditions and what is being medically required and recommended by your own doctors, this is an area where you can resist the adjuster to say, it's not that I don't want to necessarily, it's that my doctor is saying it's going to make me worse if I put myself through this. So is there further information that you need, insurance company? Happy to provide it. And by the way, here's another medical note from my doctor that says, if I submit myself to another IME, I might set myself back in my therapy and my progress and my ability to potentially return back to work.
Hey, I know we gotta fly in about a minute, but are you still finding a lot of resistance when it comes to mental disabilities with insurers? I hope they've learned a lot by now, but it's still lingering, right?
It is still lingering, and they're getting creative in the excuses that they provide, right, John? And so now they're not saying that depression isn't severe enough or anxiety isn't severe enough. Now they're looking for other technical reasons like the pre-existing condition clause or, this is all workplace related, like we talked about earlier on in the show. And so, insurance companies at the end of the day are there to make profits. They want to collect those premiums and they want to resist claims. And they come at it with adjusters that don't necessarily have any background or, abilities to look at these kinds of claims. And so at the end of the day, you're going to get a no. But if you seek some help, hopefully we can help you and we will make that no into a yes.
Good stuff. Thank you, Marcus. Appreciate you reaching out. And that is pretty much it for this week. You guys want to join us on a future show, do that through email or mydisabilityquestions.com. That is help@disabilityrights.ca. And always use that phone number, right? 1-855-821-5900. Catch you next time on the Disability Law Show.